call the first case on this morning's docket, case number 117315, State of Kansas v. Jimmy Lee Murdaugh.
May it please the court, Sam Shire appearing on behalf of Jimmy Murdaugh. Your Honor, may I please reserve 3 minutes of rebuttal argument?
3 minutes is granted.
Thank you, Your Honor. To briefly recap the procedural facts of this case, approximately 10 years ago, Mr. Murdaugh pled guilty to 2 counts of aggravated robbery and 1 count of simple robbery. At sentencing, the district court determined that his criminal history score was A and imposed a 233-month prison sentence. Mr. Murdaugh appealed. On appeal, this court held that the district court had erroneously scored pre-KSGA prior convictions for out-of-state crimes as person felonies and remanded this case for resentencing. At resentencing, the district court followed this court's appellate mandate, which resulted in Mr. Murdaugh's criminal history score being reduced from A to C. This also had the effect of reducing his prison sentence to 102 months.
Was that sentence final? Was
Yes.
The mandate issue on the resentence, it was final?
On final. The state did not file a notice of appeal.
Okay.
About 6 months after resentencing, this court published State v. Keel, which overruled the Murdaugh opinion, which resulted from Mr. Murdaugh's direct appeal. 3 business days following that publication of Keel, the state filed a motion to correct Mr. Murdaugh's purportedly illegal sentence. The district court eventually granted that motion and then imposed a 233-month prison sentence. Mr. Murdaugh appealed that sentence, and on appeal, this court, sua sponte, transferred Mr. Murdaugh's case to this court. So that is how we got to where we are today. Moving to the legal issues of this case, there are 2. The first being a res judicata claim, and the second being a Wettrich illegal sentence claim. And unless this court desires otherwise, I'd like to start with the res judicata issue. And in doing so, I'd like to begin by quoting from this court's 2008 State v. Conley opinion, which says, res judicata applies to motions to correct illegal sentence filed pursuant to KSA 22-3504. Such a motion may not be used to breathe new life into an appellate issue previously adversely determined. The Conley opinion continues by noting that the at any time language in KSA 22-3504 is, quote, not an authorization for do-overs. And the reason I would like to begin by noting that language from Conley is because I believe that unless this court is inclined to overrule its precedent, it cannot find merit in any of the arguments which the state makes in its brief. This is a case in which this court issued an opinion. Mr. Murdaugh appealed his sentence, raising an illegal sentence claim. He won that illegal sentence claim. This court issued an appellate mandate. The district court, as it was required to do by statute, followed this court's mandate, and that sentence became final. The rights of the parties in this case should have been settled. This is exactly what res judicata is intended to prohibit, what happened in this case. And I will concede that the doctrine of res judicata does not apply as broadly to illegal sentence claims as it does to typical legal issues. Typically, res judicata applies to any issue which was raised or which could have been raised in a prior case. But this court's case law is very clear that although illegal sentence claims may be raised at any time, they may not be raised successively, which means res judicata applies when an illegal sentence claim is actually raised is actually litigated and is actually ruled upon by an appellate court. The state in this case just wants a do-over of Mr. Murdoch's first sentencing appeal.
They want the application of new law, right?
They want the application of new law, yes.
And so is that a res judicata issue, or is it a different kind of an issue?
It's a res judicata issue because the issue in Keel and the issue in Murdoch are exactly the same. The only difference is the change in result.
The only difference is Keel, right?
The only difference is that the court ruled one way in Murdoch and another way on Keel on exactly the same legal issue. And the whole point of res judicata, Your Honor, is that it doesn't matter whether the law changes. The point of res judicata is to settle the rights of the parties. It's not an estoppel on the law. It's an estoppel on the rights of the parties. And when Mr. Murdoch was resentenced, and that sentence became final, he had every right to believe that this issue had been finally determined in his favor.
That's a procedural bar to considering the merits, right?
Yes, Your Honor.
If we disagree with you on that, on the merits, was Mr. Murdoch's sentence illegal?
No, Your Honor. And the reason I would say that is because the state is making the argument that this sentence is illegal because it does not conform to statute. I would disagree, because when this court issued its mandate in State v. Murdoch, the district court was statutorily required to abide by that mandate. The district court had no choice but to score Mr. Murdoch's criminal prior convictions as non-person felonies following this court's mandate. If the court had done anything else, it would have been imposing a sentence which was not authorized by statute. So because essentially what this court is arguing, what the state is arguing, is that the district court imposing a statutorily mandated sentence, imposed a sentence which did not conform to statute. And I just don't think that's a tenable argument to make.
What we're really talking about is the point at which we make the determination of illegality. When the motion was filed or when the sentence became final, right? Because when the motion was filed, it didn't conform to the law at that point. But when the sentence became final, it did.
It did, and
so tell me why we use the imposition or the finality of the sentence as the touchstone for triggering 223504 motions.
Your Honor, I think my response to that question is that because in this case there is an appellate mandate that statutorily requires the district court to abide by the Murdoch opinion.
So you're saying that if John Doe was sentenced at the same time as your client, and the Murdoch case was the law, but there wasn't an actual mandate in John Doe's case, that it would be a different result? That your client gets the relief only because there was a mandate, not because the law was the law?
Well, Your Honor, that John Doe would be in a different boat. He would have a much more difficult argument to make to this court, I believe. But I believe the mandate really takes this out of debate.
Even though John Doe's sentence would have been legal when imposed under our precedent.
Yes, and I think there is an argument to be made, certainly there, that John Doe's sentence would be illegal. The legislature, as this court's aware from its prior arguments this week, has clarified that a sentence which was legal at the time it was imposed cannot subsequently become illegal.
Question is, I think their language is pronounced isn't it? The legislative language is pronounced rather than imposed. And we're talking about finality, which can be a different point if there's an appeal, obviously. Because finality doesn't occur until the sentence is actually approved on appeal.
Yes, and this case is in a different boat than most other illegal.
This one has the mandate overlay, not just finality generally.
Exactly, Your Honor. And one thing I would like to point out is that when the district court resentenced Mr. Murdaugh, this court's appellate mandate was still in effect. That was still filed in this case. And this court has clarified in Kleypas that a district court has no statutory authority under any circumstances to get around an appellate mandate. That's just not something a district court can do.
On the issue. Kleypas is about the mandate on the issue.
Yes, and this is exactly the issue. This is exactly the illegal sentence claim this court ruled upon in Murdaugh. And one thing that I'd like to close on is that the state's argument is that res judicata doesn't apply here. I don't think that conforms with this court's case law. But assuming that that's right, that what we're dealing with is law of the case, I don't think we have any equitable exceptions to law of the case for two reasons. First being, we're really in the mandate rule area, and there's no exceptions to the mandate rule. And the second being, I don't think that we have any manifest injustice or a clearly erroneous ruling. When the district court resentenced Mr. Murdaugh, it clearly did so appropriately. It had no other statutory option.
Back to the procedural bar. Would you agree that the issue of whether or not Keel applies to Mr. Murdaugh's sentence has never been litigated? Or had never been litigated at the time the state filed its motion to correct an illegal sentence?
Yes, Your Honor, I suppose.
So wouldn't that preclude the application of the procedural bars?
I don't believe so, Your Honor, because it's the exact same legal issue.
Well, it isn't. You just conceded that it had never previously been litigated.
Well, the underlying issue is, may these pre-1993 non-KS or pre-KSGA
The issue of how to classify the issue of Mr. Murdaugh's criminal history is the same underlying issue and has been all along.
Yes, Your Honor. And the fact that the law has changed, again, that's exactly what res judicata preclusion anticipates, is that parties can't lose a lawsuit, lose a criminal case, and wait for the law to get better. That's the very purpose of res judicata. And so that's why I think that the state shouldn't have been able to file a motion to correct an illegal sentence in this case.
You cited to Conley, but you didn't mention Dickey 2.
Yes, Your Honor.
And you're aware in Dickey 2, at least in that context, it said arguments concerning retroactivity and res judicata are all unavailing in the context of a motion to correct an illegal sentence, which can be made at any time.
Yes, Your Honor. And that gets to the argument that I was trying to make earlier, which is that when an illegal sentence claim intersects with the doctrine of res judicata, it takes away the when problem of res judicata. A party can raise an illegal sentence claim at any time. It doesn't get rid of res judicata's bar on successive claims. And I think that's what the Conley case makes very clear, is that yes, this claim can be litigated at any time, but it can only be litigated once.
That just goes to the question of whether or not it's successive, if in fact it's a different legal theory being put forward.
It's different legal authority that the state is relying on, but the issue is exactly the same.
Okay.
The state's position is that these pre-1993 out-of-state convictions should have been scored person. They have new legal authority to support their issue, but the issue is the same, Your Honor. And I see that I have gone over my time limit. I would submit the issues in the supplemental brief on the briefing, unless this court has any questions on those. And I would respectfully ask this court to vacate Mr. Murdoch's current sentence, overrule the district court's ruling on the state's motion to correct illegal sentence, and clarify that Mr. Murdoch's true sentence is his 102-month prison sentence.
And real quick, fact clarification, where is he right now in terms of these sentences? If you prevail, my understanding he's already completed the underlying sentence. Is that a correct understanding?
He's completed the 102-month sentence. Right. He hasn't completed
the sentence we're here litigating. He completed, but he's still under sentence because the district court, quote unquote, corrected it. Is that right?
That's right. If he won this appeal, it's my understanding that he would just walk out of prison if he won this appeal.
Do we have any further questions? Thank you, counsel.
May it please the court, the appellee, State of Kansas, appears by Stephen Obermeyer, Assistant Solicitor General. I would similarly like to cover the claim preclusion issue and the district court's explanation of its law of the case analysis, and if we have time, discuss the Illinois robbery statute. The district court's analysis when the motion to correct sentence was filed dealt with the law of the case, and the court cited State versus Perry and said that the law of the case is not an inexorable command and may yield in compelling circumstances to avoid a clearly erroneous ruling and to prevent manifest injustice. And the court ruled that the State versus Keel, combined with the amendments to the criminal history statute, prompted the court to consider whether or not the exception to the law of the case should apply. And the court stated that a wrongly decided case is substantially the same as a clearly erroneous ruling, according to Perry, and the law of the case may yield in compelling circumstances to avoid a clearly erroneous ruling. And so that was the analysis that the court used in making its ruling. It was not.
If we disagree with that, if we disagree with the premise that an overruled case or a modified case fits that exception, where are we?
If you disagree with the court's analysis that it's not clearly erroneous, then I think that it would be reversed. The court did not base.
It's a prudential doctrine, right? Law of the case.
Correct.
And so the exceptions would be prudential also, correct?
That would be correct as well. That was what the.
If we found it would be manifestly just to give this defendant the benefit that he acquired by appealing to our court, is that the end of this?
Could you restate that, please? If it was manifestly
If we think
just.
it's manifestly just
Right.
that Mr. Murdoch get the benefit of the law of the case,
Okay. Yes.
oh, we're done, right?
Yes.
Okay,
that
that's where I'm getting.
How is the decision whether or not to apply Keel to Mr. Murdoch's sentence law of the case? It had never before been decided.
Keel came down about 5 or 6 months after the Reese.
I'm asking the question, why are we even talking about law of the case?
Well, it's I guess the law of the case as far as the mandate from Murdoch 1.
The issue that the state wanted to litigate was whether or not Keel applied. That's correct, right?
Correct, in the motion to correct
And
sentence.
that was a new issue.
That
There's no law of the case on that question.
there's not. That was the basis for the motion to correct sentence, was the impact of Keel on the sentence that was imposed.
Was the new sentence on remand from this court after his direct appeal legal at the time it was pronounced?
It followed the court's mandate that it be resentenced as a criminal history C.
So it was legal at the time it was pronounced.
It was legal at the time, but I'm not sure that's the analysis. And I would direct the court to State versus Neal and State versus Martin. And State versus Neal, for example, was a case where the defendant challenged his 3-person misdemeanors in a direct appeal, and that was affirmed. And then 7 years after the case was final, after Mr. Neal had been sentenced, he filed a motion to correct a legal sentence, arguing that his criminal history was improperly calculated on the basis that the misdemeanors were without counsel. So, when is something final in the context of a criminal history score, and then you have the language as far as the motion to correct sentence can be raised at any time.
How does Neal suggest that we look at a different moment in time to determine legality or illegality?
Well, Neal's initial conviction was in December of 2000, and his sentence was being reconsidered 7 years after that.
Well, it's true that he raised a motion to correct an illegal sentence and brought a new claim because the statute says at any time. But in my reading of Neal, Neal doesn't address the question of what moment in time do we look to decide whether or not a sentence is legal or illegal.
I don't think there's a case that does say when you look at.
There's no case that says we look at a point in time other than the time of finality, is there? Not explicitly.
Would that be sentencing?
Yeah, the
Then?
finality, either at sentencing if there's no appeal taken from the sentence, or at the conclusion of a direct appeal. That's when the sentence is final, right?
Are you?
Technically, I guess, but there's scores of cases where the sentence is final and they file a motion to correct
Right.
sentence.
But the motion to correct is still going to ask the question, was it legal at the time it was final, right?
And it usually applies some case that had come down since it was final.
Is that true? Can you cite to any case which approves of that practice? I'll just tell you, I don't know of such a case.
And just so we're clear, I think we're talking about, we have a sentence imposed, and we have a motion to correct, sometimes some years later. And do we have any cases where the sentence was legal when imposed, but intervening events made it illegal when the motion was filed, and that motion was granted based on the intervening illegality of the sentence, rather than, now it may have been, say, an application of Apprendi to a 2001 case or whatever, but the law wasn't intervening. I think that's what we're asking here.
I think this court and the Court of Appeals has considered several cases where convictions are final based on person felonies that happened before the Kansas Sentencing Guidelines Act. And then Murdoch came along, made those all non-person felonies. And there was many motions to correct sentence as a result of that years later, where that was the case.
Sorry, I didn't mean to cut you
Sure.
off. Is this a fair characterization? The 2017 amendment to KSA 22-35043, which says change in the law after a sentence is pronounced does not render that sentence illegal. Basically, it could be argued that that was designed to cut off criminal defendants from later coming forward saying, well, the law has changed, now my originally legally imposed legally imposed sentence is now illegal. Arguably, that's what the legislature is trying to do. In other words, cut off those defendants. Is that a fair statement?
I think so.
That can be argued at least.
Yes, if there's a change in the law afterwards, yes.
And what the state is here arguing is that when there's been a change in the law, that can be used to benefit the state. Because his argument is, I had a legally imposed sentence,
Right.
and now there's been, it should remain that way, and your argument is, well, the law's changed, it's now illegal, so we're going to go back and make sure that that's been changed. Is that where we are?
I think that, well, as far as the subsection 3, this happened in May of 2017, so this is after.
I
the
understand,
sentencing,
but putting aside the retroactivity,
Right.
just, is that, an argument can be made that that's what the state was trying to do? They were trying to cut off defendants from coming forward later saying, well, the law has changed, now my sentence is illegal, that was legal when imposed. And the state says, we don't want you to do that. That can be characterized that way?
I mean, I haven't looked at the testimony, but I think that would be a fair characterization to cut off where somebody was sentenced and the law, in effect, there was nothing to complain about. And then the law changes. You have a Murdoch, you have an Apprendi, you have the Hard 50 cases. And so the law changes after they're sentenced, 10 years, however many years later, and now they're saying, hey, I want that case. Just like here on issue 2, there's a 2017 Court of Appeals case that says an Illinois robbery is a non-person felony. So, and they want to apply that, even though at the time that Murdoch was initially sentenced, it was a person felony.
But in effect, what the state is doing is saying this is a one-way street. The defendant is precluded under the 2017 amendment from coming back trying to say the law's changed, now my original sentence is illegal. And you're saying cannot do that. But if the law's changed for the state's benefit, what was once legal is now illegal because of a change in the law, we can go back and change that. Is that a fair statement? If not, tell me where I'm wrong.
I would say it's a two-way street still. The purpose of that subsection 3 amendment was any change of the law would apply to both state and defendant, I think.
Would it apply to change a sentence? I thought it says exactly the opposite. That a legally pronounced sentence is, you're done. And a later change in the law cannot be used to make it illegal.
Right.
Correct.
And isn't that exactly what you're trying to do here? I asked you a moment ago whether that sentence was legal when pronounced, and you said yes. Because, in fact, it was mandated
Right.
by this court after his direct appeal. It was legal when pronounced.
Right.
The chief is just trying to say, why would that statute not prevent you from doing the same thing that it purports to prevent defendants from doing?
Right.
Well, this statute, if you apply this statute retroactively.
And I understand it came later and all that.
Okay.
Putting that aside for a moment.
Okay.
Aren't you trying to do today exactly what that statute says cannot be done?
This was why they wanted to make it that way, so you couldn't go back and a change in the law have it impact somebody's sentence.
But
So
that's
is
what
it
you're trying
necessary
to
to
do.
your, excuse me,
No, go ahead.
is it necessary to your argument today that that statute not be retroactively applied to parties in criminal cases?
If you retroactively apply this, then
You're out of luck.
yes,
Okay, thank you.
yes.
And on that point, sorry, I'm going to follow up.
Go ahead.
I'll just follow up on that precise point and ask you about this court's decision in State v. Lee, which came in 2016,
Okay.
prior to the statutory amendments. And in State v. Lee, which was Mr. Lee had advanced a motion of correcting legal sentence, and we said Lee seeks application of later case law to the statute that was in effect at the time he was sentenced. Lee was sentenced under a statute that did not, at that time, conflict with any other law, conflict with any other higher court decision. So we didn't give Lee relief. Doesn't that essentially say the exact same thing as the 2017 amendments?
To apply later case law,
We said he seeks application of later case law to the statute that was in effect at the time he was sentenced, and at the time he was sentenced, his sentence was legal.
I guess it would be the same, but
So if we applied our decision in Lee, at least that language that I read, the state would lose, right? This case.
Yes, but you have the Dickey 2 language that as far as res judicata or I
Those
guess
are
that
all
doesn't
procedural
address-
questions. This is a merits question.
I guess that doesn't address a change in the law.
Okay.
Probably, yes, I think that would be correct. Just going back to Neil, that there'd been a mandate, law of the case, and then that changed. And State versus Martin also cited there was a 1992 person felony burglary conviction to a dwelling, not challenged when the conviction became final at the initial sentencing. And then 2 years later, we have a motion to correct sentence. And so that sentence was not final, and Martin got a corrected sentence. Just anecdotally, there was in a motion to correct sentence case in State versus Ford. It was a case that Justice Lukert wrote the opinion on, dealing with retroactive competency evaluation. It was a case of last impression for a motion to correct sentence. It got remanded. He pled guilty in 1994. That got set aside, and he went to jury trial last week, 2 weeks ago in the 10th Judicial District. About an 8-day trial. You would think there'd be finality when he was sentenced in 1994, but no. So I'm just not sure when a case is final. And there's many cases where we go back to after Murdoch or whatever, pre-guideline cases, and now we're scoring them as non-person, or let's say they didn't have counsel at the time, and so those misdemeanors don't count. So for those different reasons.
But the statute, look at the statute. The court may correct an illegal sentence at any time. We throw out that at any time, quite often. But does that mean the timing at which the correction can occur, or is that the timing at which the illegality can occur? It seems to me that at any time is addressing the correction, not that the court can correct a sentence that becomes illegal at any time. It just means that an illegal sentence can be corrected at any time. Does that make any sense to you? And what we're saying that if that's correct, then the at any time would not allow the correction of a sentence that was legal at one point and that at a future point becomes illegal. We have to make that determination of when the illegality is determined. That isn't explicit in here.
Correct. If you interpret that statute to mean that any time modifies when you're correcting it, you can certainly do that. And if you looked at the case law on this statute, even it was enacted in 1970. It was based on Federal Rule of Criminal Procedure 17 and maybe an Illinois statute, I think. No case law on this statute until the Sentencing Guidelines Act basically went into effect, or maybe the turn of the century. So until then, there weren't a lot of cases on what this meant. And subsection 2 talks about clerical mistakes and judgments, oversight and technical errors. But at any rate, you could interpret it as you see fit, certainly. I see I'm out of time.
We've taken a lot of your time with our questions. Would you need a little time to wrap things up, or at least summarize?
I would just rely on the supplemental brief as far as the criminal history issue on the motion to determine the Illinois robberies to be non-person felonies, and would state that the state's intention on Mr. Murdoch's sentence from the initial sentencing was that he was a criminal history A, and that those should have been scored as person felonies, and that's not a change in the state's position when it filed the motion to correct his sentence. He was convicted of robbery and involved some women that were in their upper 70s and 80s, and this is exactly the type of person the Guidelines Act was meant to include, and I think I'm sorry.
No, you finish.
The reconsideration of the law of the case analysis by the district court supports that there is a manifest injustice, and would ask that that be affirmed.
Yeah, and so you're saying that you still disagree with Murdoch's determination on the merits as far as whether the Illinois convictions were person. But when that went back for resentencing on mandate, did you have to do anything to preserve that continuing objection to how it was scored? You understand what I'm saying? You argued that in Murdoch, and the state lost. Mm-hmm. And can you still argue that we should go back and revisit that now? Is it preserved for us to argue it again?
Well, I think the appellant filed the request for supplemental briefing on the Illinois robbery case after State versus Cannon came down. So, the court did score that as a person felony on the resentencing, I think, and I don't know if the state had to cross appeal or do anything to preserve that.
Okay.
All right. Thank you, counsel.
Thank you.
The only point that I'd like to add on my rebuttal is that this court never recalled the mandate that it issued following Mr. Murdoch's appeal. This mandate was in effect when Mr. Murdoch was resentenced, and it was in effect when he was resentenced again. And I don't think that there's any doubt, and the state conceded, that the district court's remand sentence was legal pursuant to this court's mandate. That means that the district court, when it resentenced Mr. Murdoch yet again, was not sentencing him pursuant to this mandate, which was still in effect.
So procedurally, what the state should have done to obtain relief under your current argument is filed a motion with this court to withdraw its mandate and reconsider the case based on subsequent case law?
Two answers, Your Honor. The first being, in Kleypas, this court suggested that that is a possibility for a party to pursue that course of action. But my second answer is that in this case, that wouldn't be permitted because the issue had become res judicata. And unless this court has any further questions, I'm prepared to conclude my argument at this time.
Any more questions? Thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement.